Ladies and gentlemen, hello. My name is Paul Cheng, and I wanted to thank you for coming to my channel. I wanted to thank you for joining me. Today, we're going to be talking about and going through more of the information regarding hire to fire, both from the employer side and the employee side, so you know your rights and obligations in California. California leave laws, there's a lot of leave laws, meaning that there's a lot of ways for an employee not to be available or come to work. I want to talk about two big ones, and I'll kind of go over different leave laws as well. But California leave law, you're going to have FMLA, CFRA. Really, you're going to talk about CFRA. Because CFRA was changed during the pandemic. It used to be 50 employees, now it's 5. So if an employee comes to you and they say, hey, look, I need to be able to take care of myself, my family, my loved one, you need to allow them to leave for 12 weeks. Unpaid, but it's 12 weeks. So it's quite a lot of time for an employee to leave, 3 months. Now, California also changed the law, which says you cannot replace the employee, even if they are a key employee. So CFRA used to be 50 employees. An employee can be able to leave, but you can replace the employee if they're a key person, meaning like super important, but no longer. So in California, you cannot replace the employee even when they leave for the 12 weeks, even if they're called key man. They used to call a key man or key employee. You can't replace them. You could be able to bring in a temp, but that temp's got to go as soon as your employee comes back. I was going to say pregnancy discrimination, but the pregnancy leave law allows 4 months. So you really have a total of 7 months. See this? That's why I'm not a doctor. 7 months for an employee, both CFRA and pregnancy, during that period of time to be able to take care of themselves. Now there's another law that a lot of employers, even big employers, have a problem with. Right now, I'm in a pre-litigation lawsuit where an employee actually was given 9 months of leave. And that employee had an eye problem, and the employee asked for just a few more weeks. And the employer said, no. California has what's called reasonable accommodation, and the interactive process. And I always tell employers, do not have fixed days. So many employers, big companies say, your CFRA, FMLA, pregnancy leave is done. If you are not back at the 7th for the 3+4, right, total of 7 months, if you're not back on the next day, you are terminated. Under California law, illegal. Why do so many big companies have that problem? I'll tell you why. They don't hire California attorneys. They hire attorneys out of Chicago, New York, Florida, Texas, right, where the company is based. So they don't understand all the nuances of California law. California law is very clear. If you provide a fixed date for the employee to return, and it is reasonable that you give them just a little bit more time, it is illegal. You have not provided a reasonable accommodation. You have not engaged in the interactive process when you terminate the employee because they do not come back based on a fixed time. Full stop, that's it. So many lawsuits, so many big companies have that problem because the employer is not based in California and hire out-of-state counsel. Did you know that in California there is a law that you can violate? It's failing to explain to the employee all of their rights. So a lot of times what the employer does is they say, you need to come back. You asked for CFRA, but you didn't ask for anything else. And because you didn't ask for anything else, what I did was legal. That's illegal in California. So in California, your HR needs to explain the rights and push the rights onto the employee. So if your employee says, oh, I need to take CFRA, you need to gently say, oh, well, maybe you will also be qualified for pregnancy leave. I'm not asking you if you're pregnant, but maybe it's a pregnancy issue too. If that's the case, it's not just 3 months, it's a total of 7 months. Just let you know. The employee's like, wow, I didn't know that. And the employer needs to be able to say, yeah, that's why I'm telling you. Because in California, if you don't push the benefits onto the employee, you don't let the employee know that they have those rights, that's illegal. Why is that illegal? Because California says the experts are the employers, not the employees. A lot of employers are going to say, wait a minute, I'm not an expert either. I'm not an attorney. But in California, that's too bad. That's the way California law is. Very quickly, wanted to talk about the different leave laws. If you could be able to look it up, it would really help you. Because I think I get so many lawsuits on leave laws that I like to list them very quickly. FMLA, CFRA, ADA, FEHA, PDL, and WCA. What do they stand for? Family Medical Leave Act is the FMLA. CFRA is California Family Rights Act, that's CFRA. ADA is the American with Disability Act. FEHA is California Fair Employment and Housing Act. PDL is Pregnancy Disability Leave. And WCA is the California Workers' Compensation Act. If you're able to have all of those in a chart in front of you, HR is really going to benefit. And even as an employee, if you have all of those leave rights in front of you, that's going to benefit you a lot. I lastly wanted to talk about termination of an employee. A termination of an employee is in California. Many people come to me and they say, well, it's at will, at will, at will, at will. They use that word, at will, at will. They don't really know what that means. At will basically means that there's no fixed contract. I mean, unless you have a contract. But there's no fixed contract, meaning an employee can leave anytime. Employer can fire anytime. The problem that I have is that most employers take the at will too seriously. And what that means is you walk in, they fire you. In my opinion, for California at will, when an employer terminates an employee, I always ask the employer, although California doesn't require you to justify it, can you be able to justify it if the employee were to sue you? And many times employers cannot. They just say, I've been unhappy with this employee, it's an underperforming employee, and California is at will, therefore I terminate. The problem is if you're sued and you aren't able to justify your reasons for termination, the employee will usually win. Because an employee is able to say, hey, look, I was discriminated against, I was harassed, I made a complaint. And the employer says, well, you're underperforming. You're constantly late. Well, if you have no time cards, how do you show that the employee is constantly late? For example, if you say this employee is the worst performing employee in your entire company, how do you have that data to justify it? I understand that's not illegal. It's really a best practices issue. But I find that constantly is the problem in litigation, is the employer gives a justification and that justification cannot be proven. And then basically the jurors default to, well, if the employer can't justify it, it's got to be the reason the employee said so. So when you terminate an employee, the first thing you need to ask yourself or think about is, can you be able to justify it? Second one, I always recommend a severance agreement. The severance agreement, I understand most employers don't have an attorney available, but I want to say the typical severance agreement that I have errors on, I was recently given a severance agreement and I find different errors on it is, one, whatever separation date you have, you need to put it in. Because if you're terminating an employee, you need to pay them until that day. I found that to be an issue. Two, I really recommend that you put in there all the rights the employee is waiving. For me, it's typically about a page long, but if there's a specific right that you're worried about that you think the employee is going to go after you on, sexual harassment, discrimination, wrongful termination, retaliation, you really should put that in. Another thing that I see typically when I see a severance agreement that's not put in is a waiver of Civil Code 1542. What is Civil Code 1542? Civil Code 1542 says a person can waive their rights they know, but they cannot waive their rights they don't know. So I'll give you an example. Let's say you got into a car accident, boom, and someone says, hey man, just give me $1,000, call it a day. You give them $1,000. You sign an agreement. However, a year later, their back begins to hurt and they realize it's because of the accident. You know they can still sue you. Why? Because they didn't know at the time for $1,000 that they had a back problem because of the car accident. So on any settlement agreement, you need to add in waiver of Civil Code 1542. Very quickly, I'll read it to you. And it basically says, a general release does not extend to claims that the creditor or releasing party does not know or suspect to exist in his or her favor at the time of executing the release, and that if known by him or her, would have materially affected his or her settlement with the debtor or release party. So what does that mean? Again, it means that you can release what you know, you can't release what you don't know, but if you waive Civil Code 1542, you waive the stuff you know and the stuff that you don't know. Thanks for joining me. We've been talking about a lot of issues related to employer, employee, and labor law. Next time, we're going to go further on those issues to be able to discuss more detailed information and what I call hire to fire. Thank you.